All right, we'll go ahead and get started. Good afternoon, everyone. My name is Michael O'Rourke. I am the director of the MSU Center for Interdisciplinarity, and the center is the host for the University Interdisciplinary Colloquium. And we are thrilled to have with us today Dr. Folino White as our speaker. I would like to begin, though, by reading the land acknowledgement, the MSU land acknowledgement. Michigan State University occupies the ancestral, traditional, and contemporary lands of the Anishinaabe, Three Fires Confederacy of Ojibwe, Odawa, and Potawatomi peoples. In particular, the university resides on land ceded in the 1819 Treaty of Saginaw. We recognize Michigan's 12 federally recognized Native nations, historic Indigenous communities in Michigan, Indigenous individuals and communities who live here now, and those who were forcibly removed from their homelands. In offering this land acknowledgement, we affirm Indigenous sovereignty, history, and experiences. After I introduce our speaker, I'll put a link in the chat to additional information and resources related to this land acknowledgement. The University Interdisciplinary Colloquium, for those of you who are new, is a forum that is organized by the Center for Interdisciplinarity and sponsored by the College of Arts and Letters at Michigan State University. It's a forum that's designed to highlight innovative and important interdisciplinary work that involves the arts and humanities at Michigan State. Interdisciplinarity, for those of us who practice it, is often held up in a university setting as a vehicle for complex scientific work. Humanists and artists are not often included in institutional thinking about interdisciplinarity. But from our perspective in C4I, some of the most innovative and impressive interdisciplinary work out there involves artists and humanists. And so we want to use this particular series as a forum for kind of amplifying the signal associated with artistic and humanistic interdisciplinary work. And so we've been at this for a few years now and had the opportunity to provide a platform for a number of people at MSU who are doing really, really cool work that centers the arts and humanities in complex projects that are interdisciplinary in character. And this particular series runs every other week during the fall and the spring. The next session of the University Interdisciplinary Colloquium will be on the 26th of February, so two weeks from today, 12 to 1 p.m. Eastern on Zoom. I think the same link works for that session. Johanna Schuster-Craig, who is assistant professor in German and Global Studies, will be our speaker, and she will present a talk entitled Additional Training and Developmental Editing for Transdisciplinary Projects. Today, though, as I mentioned, we have with us Dr. Folino White, who is associate professor of theater studies and directing and head of theater studies and management at Michigan State University. Dr. Folino White's scholarship on U.S. theater, protest, and political performance appears in journals such as Performing Arts Resources, Performance Research, Women in Performance, The Drama Review, TDR The Drama Review, Theater Topics, and Text and Performance Quarterly. She is contributing co-editor of Food and Theater on the World Stage, produced by Routledge in 2015. Her book, Plowed Under: Food Policy Protests and Performance in New Deal America, published by Indiana University Press in 2015, received the CLR James Book Award from the Working Class Studies Association. She is recipient of the 2016 Mid-Michigan Alumni Association Award for Quality Undergraduate Teaching, and in 2017, the Michigan Association of State Universities named her a Michigan Distinguished Professor of the Year. She is editor of Theater Annual, a journal of theater and performance of the Americas. Dr. Folino White's select directing credits for MSU include The Grapes of Wrath, In the Blood, and Macbeth. In 2013, Dr. Folino White directed her stage adaptation of the autobiographical poetry collection, The Lady Victory by Jane Vincent Taylor, which explores the experiences of girls in a Catholic maternity home for unwed mothers in 1960s Oklahoma. Today, Dr. Folino White is with us to deliver a talk entitled Acting and Its Others, Labor's Role in Defining Artistic Boundaries. Dr. Folino White.
Hi, everyone. Okay, I'm going to share my screen and then I'm going to get going. Okay, I'm guessing everybody can see me. A couple of things. This project is work in progress. The archive that I was using, I was lucky enough to travel there last March. It's in New York University in the labor archive there. So I got 1 week worth of research done. The next week, the library closed due to the pandemic. So I'm hoping to resume work when travel is available. So you'll be hearing some preliminary thoughts and preliminary research. I will refer to the Actors Equity Association, which is the union that I am talking about, as equity. So when you hear that, know that that's the actors union. And finally, I am pretty formal in my presentation style just because I don't trust myself to stick to the subject. So I've got a script. So here we go. When the Actors Equity Association presents itself as it does on its website as the labor union representing actors and stage managers in the American theater, their mission seems very clear. And given the fact that equity, I'm trying to change my slide. Okay, there we go. And given the fact that equity is the representative of self-identified actors and a formidable entity with which most big-time producers must enter into labor agreements, it must have a working definition of actor, right? It sort of does. It has a vague definition. The union and this vague definition works well overall. This is the definition. An actor is a member of equity. This definition first appears in Actors Equity's 1960 rulebook, a full 47 years after the union was founded. With the exclusion of the organization's charter, which I'm going to talk about in a minute, no other definitions of acting appear in the union's membership materials or its standard contracts with producers, past or present. When I say that this vague definition works, I mean that the union and producers negotiate standard contracts every about 3 to 5 years from the position that the definition of acting and actor is clear to everyone involved. Secondly, I mean it works because while there are dozens of labor disputes about contract terms between equity members and theatrical producers that have occurred annually since the early 20th century, what is meant by acting in any given contract has not commonly been a cause of disagreement or complaint between the parties. A majority of grievances and the arbitrations to work them out are initiated over salary. Often, pay due when a show closes early or an actor is fired or quits during the scheduled run of a production. While it makes good sense for this union to avoid strict, detailed definitions in order to maintain a strong shared identity among its membership that is also flexible enough for the variances in artistic work, clarity of purpose and delineation of duties matter very much to employment contracts. And in fact, I have discovered a sizable corpus of arbitration cases in which actor and producer disagree about an actor's job, or disagree about whether the work for which they are contracted is the work of acting. In these cases, the power to define the scope and nature of acting as a job and an art form shifts from the artistic realm into the realm of labor relations. Specifically, the power is placed into the hands of an impartial arbitrator, a theater industry outsider. When established in 1913, the founding members of Equity, which were 8 actors, drew a clear line between actors in the theater that they wanted to represent and organize and other performers, which they conceived of as non-actors. Equity's charter, which you see here, elaborates which performers in which specific field of entertainment it was going to represent in labor relations. All players, entertainers who are individual in their work, who do not exclusively act in mass formation in any place where representations in English and French are given with a sustained plot. This means, and then it lists the kinds of performances: Shakespeare drama, melodrama, comedy. Essentially, equity represents performers in plays or musicals that are produced on a stage in distinction from other live performing arts genres. You can see that initially the Actors' Equity was not interested in representing chorus, those performers that work or act in mass formation. Thus, the union represents those whose performance is individuated, and that becomes the basis of their definition of acting. If you've read an equity contract or a rule book, which I tell you they are page turners, you will know that in addition to this foundational outline of an actor and the 1960 definition that I previously mentioned, equity would eventually delineate different categories of actor with a capital A, meaning the actor who is defined as a member of equity. Only the category principal actor enjoys direct identification with the term actor. And arbitrations reveal that this employment category is really the one which equity considers acting to occur. All the others are doing something else. Again, the definitions pertain to how each of these definitions in the categories that you see, to how they are contracted, right? You're contracted as this, but they don't refer to what they do in those roles. You can see that the terms part, here we go, part and role get added for the 1993 edition of the standard contract. But again, they are these all-encompassing definitions. And in the archive, there is a lot of discussion, which leads me to believe that the addition of the terms part and role came out of a 1980s arbitration where equity was trying to argue that stage managers were in fact actors with a capital A, and that performance and role and part could mean more than character. They lost that arbitration. Otherwise, to date, beyond what I've shown you in official documents, the definition of actor is not otherwise expressed in writing. The arbitrators who assess disputes are drawn from a registered roster of professionals. This is still a voluntary nonprofit group, but professionals who may or may not have some expertise in the industry where the dispute is occurring. Since the late 20th century, the arbitrators hearing actors' equity cases and producers have tended to be jurists. Arbitrators interpret only the contractual terms under dispute. Ostensibly, they don't make artistic judgments. And on multiple occasions, arbitrators have expressed their refusal or uneasiness to be put in a position to do so. For example, in his summary decision in a 1980 arbitration involving equity and Circle in the Square theater, arbitrator Daniel Collins wrote, quote, "The arbitrator cannot, of course, second guess or even review the artistic judgment of the producer or the director," end quote. As a rule, arbitrators answer a closed question. Were the terms of the contract violated? Or does the agreement cover X, Y, and Z? And if so, what shall be the remedy? Arbitration judgments and awards are limited by and subject to consideration of the specific terms of the contract. The problem comes when the terms of the contract are the matter of interpretation. In answering any closed question regarding different interpretations of the contract, arbitrators adhere to the parole evidence rule. This rule is that the final written contract is taken to express the intent and extent of an agreement. That is, if it was intended, it would appear explicitly in the written agreement. Prior agreements, ongoing negotiations, drafts of disputed contract, and so forth are largely excluded or minimized from consideration. What is written is what matters the most. Other evidence to support opposing parties' claims may be brought forth when arguing more complex matters, such as one interpretation of a term written in a contract against another interpretation of a term. Dependent upon the grievance, evidence might include artistic conventions and common industry practices, expert witnesses, as well as pertinent play scripts, rehearsal practices, analogous productions or publicity. Arbitrators may also be asked to view a rehearsal or a production itself. The influence of a single arbitration decision is limited. While such decisions are legally enforceable to the parties involved, they don't set precedents, as does jurisprudence, at least not legally or necessarily officially or directly. In 1956, however, Equity's legal department advised, quote, while arbitration awards are not precedents in any binding sense, they are persuasive and can be used effectively, especially when accompanied by an opinion that is well reasoned. So this advice was given to equity representatives who were asking about their chances of getting a favorable judgment in an arbitration that was desired by 3 performers who had been categorized as extras in Inherit the Wind. They wanted to be recategorized as principal actors. So the legal department was really doubtful about the success of this case because of a judgment that had been rendered the year prior regarding Thornton Wilder's Skin of Our Teeth. So in that case, 5 of 6 of the performers in Skin of Our Teeth won reclassification as principal actors because they ad-libbed lines as part of a crowd, but the 6th performer did not get recategorized. Even though this performer was scripted by the playwright to sit in the audience, and then when an actor on stage mentions the word adultery, this actress stands up from the audience and goes, "Woo!" And as she's so upset at even the thought of it because of problems with her husband that she runs out, okay? So the arbitrator ruled against her being a principal actor because he couldn't say that that single action of hers sufficiently individuated her to elevate her to the status of actor. He did say that he might have decided otherwise if she had spoken lines. The legal department of Equity urged that they avoid another arbitration because, as they wrote, an unfavorable opinion might hamper what we think should be Equity's primary effort to change the definition, to define the difference between an extra, if there is to be such a classification in the future, and an actor sharply, so that there can be little questions as to what side of the line a member belongs. In many recent arbitrations, we have been hampered by cloudy, perhaps purposely so, rules and definitions, which are susceptible to several interpretations, any one of which an arbitrator is free to choose. Excuse me. Equity, for better or worse, did not heed this advice. And throughout the 20th century, this freedom of choice or the burden of definition would fall to arbitrators again and again, as it did when the cast of Compulsion or The House Behind in 2012 got to talking about their contracts. And to quote cast member Eric Wright, somewhere along the line, we realized we had a different contract. So now I'm going to shift into talking about this particular case study in depth and the effects on the performers, as well as the production of Equity never providing a definition. Let's get some nice slides. Okay. Compulsion, or The House Behind, by Rinna Groff, opens with 2 writers at work, Anne Frank and Sid Silver. The character Sid Silver is an American-born Jewish writer fixated on Anne Frank and obsessed with getting his stage version of her story produced. Silver's struggle is based on the true story of Meyer Levin's interminable legal battles with Otto Frank over the stage rights to the diary, which Levin lost when Frank granted them to Francis Goodrich and Albert Hackett. In the play, the character Silver's obsession with getting his play produced ultimately destroys him. In the 2010 to 2012 productions of Compulsion, which were co-produced by Yale Rep, Berkeley Rep, and then the Public Theater, Silverman was portrayed by Mandy Patinkin. Anne Frank was voiced primarily by Hannah Cobble and set in motion by Emily DeCola, Eric Wright, and Daniel Fay. In other words, Anne Frank was bodied by a marionette. Marionettes also play Otto Frank, Peter Von Don, Meep, Mrs. Silver, and at the play's end, Patinkin interacts with a puppet version of his character. I need to be more careful, I think, in describing how and who brought these characters to life. This is because determining the nature of performing via a puppet, specifically if acting occurred, was the central issue in this complaint raised by the the 3 AEA contracted members of the cast on behalf of the 3 puppeteers and supported by the union against the theaters who were co-producing the play. The grievance the grievance challenged the actions of Yale and Berkeley reps, which did not apply the equity contract to the puppeteers. Equity and the producers argued the question whether the puppeteers in these productions of Compulsion are covered by the agreement. If so, what shall be the remedy? Equity argued that puppeteers were acting, the producers that they were not. Did they qualify as actors? I won't keep you in suspense. The arbitrator's judgment was no, but with a few caveats, which show the power of the arbitrator and the need of AEA to develop clearer definitions. The 3 reasons given by the arbitrator for his decision include, first, the ambiguity about whether the term actor as defined in the agreement includes puppeteers. Second, the absence from the rulebook of any provisions which specifically protect puppeteers. And finally, a lack of sufficient past practice that shows consistent representation by equity of puppeteers as actors. The criteria by which the arbitrator determined his finding and the evidence submitted by both equity and producers indicate the influence of historical antiquated definitions of acting by privileging dialogue over gesture and visibility over presence, while failing to account for the unique demands of Compulsion's individual dramaturgy. The Compulsion arbitration highlights labor issues that accompany the contemporary renaissance of puppetry, specifically its increasing integration into text-based dramas and musicals, or into AEA's, equity's jurisdiction. For as much as puppetry has been celebrated in mainstream commercial theater since the Lion King phenomenon, puppeteers continue to be marginalized and only recognized as actors when they meet other historical criteria. They must be seen or heard playing a recognizable character. The words puppet and puppeteer do not appear in the contract. To prove the meaning of the term actor in the absence of the word puppeteer, the bargaining history between producers and equity was entered into evidence, and the current and immediate past presidents of the League of Resident Theaters, who represented Berkeley and Yale, testified that during the previous 28 years, from 1983 to roughly 2011, that puppets and puppeteers had never been considered during contract negotiations. Neglect to consider puppeteers, of course, extends back much further to equity's founders' aims to differentiate themselves from vaudevillians and variety performers. Equity's charter, as you saw, drew distinctions between art and entertainment and artists and laborers, singular talent that individuated against reproducible skill. 80 years later, the compulsion case also highlights an underlying belief in the superiority of an actor as a complete, uniquely expressive vessel against an incomplete, interchangeable performer reliant upon objects, a very modernist idea. Their resultant ambiguous status for the puppeteer, becomes apparent in the compulsion arbitration, which suggests that equity has not kept pace with changing theatrical representations, despite reviewing the standard contract every few years. It is most apparent in how producers define acting in the arbitration, but also embedded in equity's failed argument. Though nowhere written in the agreement, during the compulsion arbitration, equity maintained the position that actor could also mean puppeteer, because equity considers puppeteers actors when the puppet is, quote, a character, part of dramatic action, or sings, dances, or voices a puppet, end quote. Further, equity entered into evidence the workshop and rehearsal process for compulsion itself, to argue that the puppeteers are actors. The puppeteers worked collaboratively with scene partners to create characters and relationships. The director, Oscar Eustis, gave direction and notes to the puppeteers. And during performance, puppeteers entered into a typical give and take dynamic, which was responsive to Mandy Patinkin's, quote, enormous amount of improvisation. Equity's argument aligns with acting theorist Stephen Tillis's conceptualization of acting, that the actor is the person who produces the signs of dramatic character, regardless of where those signs are cited. Meaning, I may produce it and it may eventuate here in this cup as I animate this cup, or I may produce it and it may appear on my body. Producers expressed a far more common viewpoint about acting and maintained that a performer must be visible and or audible to an audience in order to be an actor. They argued that when puppeteers were recognized under equity contract in the past, puppeteers were either seen or heard in these roles, or alternately double cast in chorus roles, which automatically accounted for their inclusion in the equity contract. Thus, equity could not unequivocally prove that these performers were historically recognized as actors when creating character via a puppet. The testimony of the expert witnesses called by producers further support the modernist perspective of the actor as a unified entity. One expert witness confirmed historical practice in stating that in his experience in professional theater, puppeteers have not been considered actors. Another expert witness explained that puppeteers are akin to musicians, quote, performing a mechanical function only, end quote. Sorry, musicians. While actors undergo physical and vocal training to transformative effect and maintain a direct relationship to the audience. The third expert witness for the producers called puppeteers stagehands because they manipulate props. While one expert allows for affect in equating puppeteers with musicians, and another may be denying it using a derisive reference to technicians as merely crude labor, both intimate belief in unified characterization, as well as the unique individuality of the actor against the interchangeability of a puppeteer. Indeed, history again hurt equity's argument. Among past practices entered into consideration, there were a number of occasions during which equity did not challenge the use of stagehands to manipulate puppets in productions. Equity attributed this lack of complaint on their part to the fact that these puppets were not characters central to the plot. Here's an example they used, and it's my favorite example. They were referring to a production of Pig Farm by Greg Cotis, and equity held that, quote, the pig had no name and did not speak any lines, end quote. That's a laugh line, but I'm talking into the void right now. Here, equity's attempt to explain away their inconsistent definition of acting again defaulted to speech as a measure of character and name as a measure of character, much as the arbitrator determined in the skin of our teeth case. While equity attempted to argue for puppeteers as actors, it could not make the leap from an actor's identifiable person to a perceptible presence and the production of character. This is important because the arbitrator was not fully persuaded by the definitions given on either side, finding both equally plausible and both insufficient to clarify the meaning of the term in the agreement. At the request of both the producers and equity, the arbitrator attended the public's production of compulsion as well as a production of Warhorse. Using Warhorse as a point of comparison, I think was equity's attempt to show that puppeteering is an embodied practice that affects a transformation into character. But what it did was, I think, serve to reinforce the preeminence of visibility and audibility of the individual actor as necessary to establishing a relationship to the audience. In Warhorse, if you don't know it, so this is my puppet, and the puppeteers actually embody or inhabit, I should say, the puppet. On the surface, compulsion, as you saw, is a far more familiar and traditional style of puppetry, one which maintains a visual distinction between the puppet's body and the performers by masking the performer pulling the strings, thus suggesting an affective and functional distinction between actor and puppeteer, which Steve Tillis again identifies as a false opposition. Quote, the person of the actor no more disappears than does the operator behind the puppet. The fact of the performance calls attention to that person's being. I agree with Tillis. Yet, in most cases, realism, what we're trained and how we're trained to view as spectators, work really hard to minimize the audience's recognition of the external production of character. I make this point only because compulsion, both its dramaturgy and its staging, amplified the tension between performer and character. This is to say, because compulsion is concerned with and never relieves that tension, it really could have made a great case for arguing that puppeteers do act. Compulsion actively and repeatedly calls attention to puppeteers' presence, even though they are largely unseen and entirely unheard, just as it calls attention to the individual actor behind the character. Productions of compulsion were anti-illusionistic, using minimal scenery and projected intertitles that advance time and location, as well as abstract projections and projections of historical figures. Excluding the excluding the character played by the character Sid Silver, played by Mandy Patinkin, which you can see here. The other 6 characters were played by Elizabeth Cobble, who you see, and then another actor. So they were doubling up, playing multiple characters. These 2 actors also visibly voiced the characters bodied by marionettes, with Cobble here playing Silver's tortured wife. She also plays the publisher who, quote unquote, cheats him out of Anne Frank's diary, and she's the predominant voice of the Anne Frank marionette. Within the dramatic world, the familiarity of this actress's appearance and voice to the audience is vital to conveying Sid Silver's single-minded preoccupation with Anne Frank and its effect on his professional and personal life. At the same time, this doubling calls attention to this actor's labor of producing character. A reviewer of the Berkeley Rep production made particular mention of the notable shifts performed by the 2 visible actors, applauding Cobble's, quote, chameleon transformations in her dual role as mind-bending. The reviewer, however, goes on to say, then there are the marionettes. Although they don't appear on stage, the three puppeteers, Emily DeCola, Daniel Fay, Eric Wright, are very much the stars of the show, end quote. This points to an audience member experiencing the presence of the puppeteers, their creation of a direct relationship with the audience that one of the expert witnesses testified is required of acting. For playwright Rena Groff, marionettes were fundamental to ethical representation, which is also at the heart of this play's conflict and this case. According to Groff, compulsion's central question is, who has the right to speak for this woman, Anne Frank? As an interviewer put it, Groff expressed that she mitigated her own apprehension about putting fictitious words into Anne Frank's mouth, quote, by turning the character into a marionette, an inanimate object that has no voice of its own, end quote. Groff requires a distance be carefully drawn and apparent to the audience between the characters and the actors that produce it, encouraging the exposure of performer within character. This was accomplished at the levels of stage direction, dialogue, scenic progressions, as well as in the blocking and onstage compositions, one which you see here. From the very opening moment of the play and throughout, when the marionette characters speak, the actors voicing them are visible on the stage. They're usually in a downstage corner position. And they're distinctly, so the voice is distinctly separated from the unchanging wooden-faced and loose-jointed gesticulation of their bodies. The distancing of the voice from the body parallels the discernible disconnection between the body's movement and its site of production. So what I'm talking about is this triangulation. So downstage voice projection, upstage invisible manipulation from the puppeteer, and then the body of the marionette. And what that effect is that character is purposely dispersed rather than a unified whole emanating from a single identified point. Instead, the marionette body on the stage is only one point, the voice another, and the movement imbued from above. Puppeteer Eric Wright told me that because of the exposed catwalk system above the stages at Berkeley and the public, the puppeteers were partially visible, though costumed in conventional, don't look at me, dark clothes. I'm not trying here to argue for visibility as a necessity of acting, but what I want to suggest is that the above in this triangulation becomes an active site of signification, and that in these productions, partial but not full visibility critically continued to toy with the audience's double vision, that of seeing a character and actor simultaneously. The fracturing that emphasizes the collaboration between multiple actors to produce a single character is extended throughout the play. And in this instance that you see on the screen, this scene, the Anne Frank marionette sits between Patinkin and Cobble, husband and wife. Patinkin visibly voices the marionette for the first time in this scene, creating a multi-layered dissonance. A man's voice in a girl's wooden body, talking with a woman whose voice also belongs to the girl. The staging illuminates the absence of a character's pre-existent subjectivity, or subjectivity beyond what actors and puppeteers imbue in them in the immediate stage moment. The play is a performative metatheatrical meditation. It materializes the implications of strings being pulled, as the playwright put it. But by continually drawing audience focus to the work of acting and the production of character, it reminds you of the strings. Of course, none of this is in writing in Equity's contract, and thus cannot stand up in the face of a long and living history that implicitly equates displayed individuality with acting and occlusion with mechanization. And I suspect that the arbitrator also sensed this. As I said, he found neither argument persuasive, or rather both definitions of acting equally plausible. And faced with the tension between theatrical artists trying to innovate and just employment conditions for actors. The arbitrator closed his decision by proposing the perspective question and the pressing need to equity. What should or could the actor mean? That question could be posed to another arbitrator or raised in a different forum. I'm raising it here. Thank you. Let's see, can I, hi. I'm all done. Hey, Stephanie.
Hi. So for our attendees, if you have any questions for Dr. Folino White based on her talk, please drop them into the chat.
I'm gonna drink some more water.
I'll give you a few minutes since it just ended.
Dan Smith.
Oh, we've got a big one. I can read it for you and then you can react. Do you have any insights into the recent negotiations between the AEA and SAG-AFTRA about streaming performances and how this affects the definition of theater? In relation to definitions of acting, how would it be useful to consider how SAG-AFTRA handles voice acting and animation or enhanced by CGI? Are stunt performers actors according to SAG? Are dancers in the Oklahoma Dream Ballet actors according to equity? So unpacking a lot of questions here from Dan.
Sure. Those are great questions. So the dancers in Oklahoma, yes, are considered actors according to equity. And so this is my way of answering Dan's question. Thank you for it, by the way, Dan. I really appreciate it, and I've been thinking about it. The way in which equity and the Actors Guild of Variety Artists and SAG-AFTRA all function are they define their jurisdictions not by the work undertaken by the human beings, but by the venue and the form, the genre, right? So for instance, Actors Equity is in charge of anything that happens on a live stage, which is why that fight a live stage, if the plot is sustained, right? So if it's like a cabaret, it would be a variety artist in their jurisdiction, and equity and the Guild of Variety Artists have been fighting since the beginning because equity didn't historically want them to be considered actors, but as you've gotten these jukebox musicals and these other forms, right, as artists change their forms, this is the issue with these puppeteers, the jurisdictions of these unions go crazy, right? So like in the jukebox musical, like Honky Tonk Nights or something, I think this one arbitration is over. The guild argued it's ours because it's not a sustained plot. And then equity was like, it is a sustained plot. And it had nothing to do with what the actors were doing. It was just, they were both happening on a live stage. So is it a musical or is it not a musical, right? And the new argument, which is temporarily settled between SAG-AFTRA and SAG-AFTRA is the Screen Artists Guild, and AFTRA is American Federation of Radio and Television, and those two are have merged. And of course, as you can hear in the title, they control screen and radio and television, and now multimedia. So so that's what that fight is about, right? Is it theater is part of the question that has arisen because it's now being streamed. And so who has those contracts, right? And the way that these contracts work, these fights really matter because actors are chronically underemployed, and they have to have so many gigs every year in order to maintain their health insurance and other benefits. And so whichever union you belong to and whichever union gets the contract, that's going to affect the total membership. Dan, I hope that answered that question.
And Dan, feel free to drop additional questions or follow-ups in the chat as well. We've got a question from John Peter Beck asking if there was any jurisdictional dispute between unions over who covered the puppeteers.
Yes, or not in this case, John. But the puppeteers, they often, in my talk with Eric Wright, those puppeteers based in New York, they tend to do a lot with opera, and they're covered under, I can't think of the name of the opera union, but because they're working at the Met a lot, they get covered by that. There was a recent dispute. Puppeteers tend to be covered under variety artists. And the issue again is these puppeteers couldn't be covered under an equity contract because, okay, these puppeteers couldn't be covered under a variety guild contract because they were in equity, they were performing in equity jurisdiction. So they got independent contracts at a lower wage because they were in equity territory, but doing things that equity has not recognized previously as acting. There's a, just to elaborate on this sort of where puppeteers belong, because unions aren't paying attention to the work people are doing, but like who controls TV and who controls the stage, and at Disney in California, it was a couple years ago, but Disney had a puppeteering show and they wanted to unionize. I think they wanted equity. I think they wanted to join equity, and Disney canceled the show because of the fear of how the union would change, would provide the workers with rights. So, yes.
We have an anonymous Q&A asking, when you're able to continue your research on this topic, what's your end goal? Is it going to be a book?
Yes, my end goal is a book. So I hope to answer questions that really in a number of different areas. I hope to answer questions about jurisdiction and that ongoing fight, which eventually becomes what is theater, what is acting. So I'll answer questions about that. I'm going to answer questions about various artists' innovations, like this puppeteer thing. Like puppeteering was not thought as, for a very long time until Lion King, was not thought of as real theater, right? It was thought of as things for children in the US context. In Europe, it is a hugely revered tradition. But here it was like the stuff for kids, right? Not real theater, not legit. And with the 1990 shift into Lion King, it was like, oh my God, this is artful. And more playwrights start incorporating puppeteering into this legit theater. And so innovations like that, right? Artistic imaginations disrupt union definitions. And so how those are negotiated. I'm also going to look at the change in social conditions revolving around the Miss Saigon case, but it's actually, which is 1990 as well, but it actually predates Miss Saigon. And this is a fundamental change in acting theory and the beginning of the dismantling of white supremacy underlying acting theory, which is in the realist tradition, actors are taught they can perform any role. So when Miss Saigon becomes the watershed where the union and actors establish the fact that there needs to be a parallel between the actor's identity and cultural knowledge and the role, right? And this comes to a head when the producers of Miss Saigon petitioned to bring Miss Saigon, it was a West End production, petitioned to bring it over to the US, and they get permission, and then permission's taken away because the lead actor was using yellowface. So I'll be looking at the changes in social dynamic as well. Those are 3 of the 4 big ones. I can't remember the last.
We have a question in the Q&A from Abby Taikaki, and it's, how do we reconcile the idea of an actor being a member of AEA, and what does that do for non-equity actors?
That's a really good question. The AEA is, and Abby, if I don't answer it, call me on it. So the AEA is is thought of as like a badge, a credential, the mark of professionalism. And it's not as often thought of as a union. So in this, this is true in all sorts of various realms. So it's little studied in labor relations studies. It's there's really only like 2 books on equity in terms of theater studies and theater history, and they all stop with the 1919 actors strike. It's like, we won, we got everything we wanted, and then there's no work on the living history of this really important union. So its job to work for workers' rights, for actors and stage managers' rights, is not really thought about. But it's not that it's like this false consciousness that people think it makes you a professional, because in fact, that's how it actually works. So if you're an equity member, you have access to work in a way, it functions like a credential, right? Like you need an equity membership to get an audition, or you need an equity membership to to be seen, to be big time, all of that kind of stuff. There are other markets in which smaller markets, and that it's not necessary, but it in order to make art, but it is by and large necessary in order to make a living as an actor. Equity isn't a closed shop. It's like a 80-20, I think. So like 80% of the actors any producer wants to employ, my number, it might be, I think it's 80-20. 80% of actors must be union members. And then if you're not, if a producer wants to hire you, and it's an equity contract, which it would have to be for Broadway or 99-seat theaters or any LORT members, any of the commercial producers, for-profit or nonprofit producers, that 20%, a producer could contract me since I'm not an equity member, but then I have to join the union. I don't know if that answers it. I went on.
I'm gonna, Abby says, yes, thank you. We have a question in the Q&A from Brianna Beeman that says, can you speak a little bit more about the stakes of performers like puppeteers being considered actors or not under the AEA definition? Not just the stakes of equal pay with principal actors, but for example, if a performer were to experience racialized or gendered harassment from another member of AEA or the production team during the production, or is that out of the realm of the AEA's protections and services?
It is. So if that puppeteer experienced harassment by an AEA member, let me think. No, that because there would be no protection from them from the union. If the arbitrations occasionally do concern like equals, essentially, 2 cast members in a fight, if they're both members of the union, an arbitration may be called to settle it. Arbitration is in every contract that the AEA has, but usually it's between producers, those with more power and those with less power. Now, the thing that is at stake for those puppeteers and others who don't qualify, right? And even for like the extras, are things like working conditions in terms of the number of hours they rehearse, pay, as you mentioned, but also those other protections as well. And one thing Eric Wright said to me when I was talking to him about this is respect and recognition is at stake, because AEA is that credential. I'm sure it appears on every, if I'm looking at people for jobs, if I'm ever on a search in academia, that membership, like my academic affiliations, functions as a credential. It is sort of taken as proof of fact that you've made it. You're good at your job. That's how it functions.
So we've got 4 minutes left, which means we probably have time for one more question. And I'm also interested in this question that Dan Smith has put in the chat. And he's curious about the relationship between AEA and the Dramatists Guild in the case of writer performers like John Leguizamo or a Heidi Schreck.
Okay, so I'm not going to answer the John Leguizamo question because he's usually performing his own work. But that's number 4 in the 4 chapters. So the other question about the definition of actors is the way in which plays are written, as Dan knows, being a dramaturg, new in the more contemporary period, is a lot of plays are in workshops, and when a play is being worked in workshop, it becomes a collaborative experience oftentimes. And there has been a number of arbitrations in which equity has fought for actors as creators of roles. And so there has been conflict with the Dramatists Guild, and the height of this conflict was in it was the late 70s, early 80s with the rise of off-Broadway. So what happens is off-Broadway and off-Broadway are these sort of non-commercial things, and playwrights and actors are all getting together and experimenting, right? And then Broadway takes notice, and stuff that appears off and off starts getting moved, right? Investors, and then it moves to the big commercial stages. Well, the playwright's name goes with it, but oftentimes the actors who were working on these productions were being replaced by bigger names, by people that would draw. And so equity was fighting for actors to get some sort of payment and some sort of credit for these roles that they create. So then that question becomes, do actors merely embody a role? And then are they interchangeable, right? Which equity fights really hard to say they aren't. Or through their embodiment and through these workshops, are they co-creating, right? I know in my experience as a playwright, and I'm sure Dan knows in his experience as a dramaturg, in those workshop processes, the actors often go, that line doesn't work, right? Or what if she said this? Or I think my character would. So they're active participants, but they're not considered authors.
So unfortunately, we've reached the end of our time today, and I want to thank Dr. Folino White for making the time to come and give this University Interdisciplinary Colloquium for us today. I'm sorry to those of you who have questions that we weren't able to answer in the time.
You can just email me.
There you go.